एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए.
Hello everyone. Welcome to a very new episode of the Goa State Legal Services Authority's virtual Juridicare series. I am Advocate Tina Bosley, Legal Assistant with the Goa State Legal Services Authority. First of all, on this joyous occasion of Liberation Day of Goa, I extend my greetings and good wishes to the people of Goa. The Portuguese Civil Code 1867 that came into force in July 1870 in the erstwhile colonial territory of Goa is still applicable in parts to this region, along with relevant procedures from the Civil Procedure Code 1939. In its full form, it has 4 parts and 2,538 articles. That was a most comprehensive piece of legislation. Post the liberation of Goa in 1961, some 300 Central Indian laws were extended to the state of Goa, and large portions of the 1867 Code stood repealed. Under such laws in this region, marriages are a civil contract and have to be compulsorily registered in a civil registry to have civil effects. One of the most important aspects of such marriages is the 4 systems under which property is governed within the marriage. The general principle is that of communion of assets and properties, where the properties owned by both spouses are held equally, though administered by the husband. There are provisions for absolute separation of assets with the signing of a prenuptial public deed and simple communion of acquired assets with antinuptial deeds. Consents and concurrences of both spouses is needed for alienation of immovable property. Today, to share more light on this said topic of antinuptial deeds in the state of Goa, we have with us today Advocate Shri Gustavo Monterio, who is a practicing advocate from Panjim. Advocate Gustavo Monterio has completed his LLB and LLM from the V.M. Sargaonkar College of Law, Miramar. He has a credit of coming in first place for his LLM dissertation on the topic of a critical study in the law and procedure relating to guardianship and adoption in the state of Goa. I welcome him for this session of virtual Juridicare series and request him to share his thought on the topic of antinuptial deeds in the state of Goa.
The topic that I'm going to speak on today is anti-nuptial deeds. However, it is not possible to speak purely about anti-nuptial deeds, as there are various points of law connected to this subject and which need to be explained in order to understand the concept of anti-nuptial deeds. India is a nation of varied customs and communities, and many religions and cultures are found in it. This has resulted in various religious communities being governed by different personal laws with respect to marriage, divorce, succession, and so on. While Article 44 of the Constitution provides that the state shall endeavour to provide for its citizens a uniform civil code throughout the territory of India, the same has not yet turned into a reality, as each religious community has its own personal laws governing marriages, divorces, succession, etc. These personal laws further came to be enacted as legislations. For example, the Hindu Marriage Act, the Hindu Succession Act, the Christian Marriage Act, the Dissolution of Muslim Marriages Act, and so on. In Goa, on account of the Portuguese governance, we are fortunate to have the Civil Code of 1867, which governs marriages, divorces, and the succession of the people to whom the Civil Code applies uniformly. The Civil Code, as originally enacted by the Portuguese, was an all-encompassing law governing the various facets of a person's life. With the passage of time, various new laws were enacted to adjust to the changing social and political scenarios. These included the Law of Marriage 1910, the Law of Divorce 1910, the Code of Civil Registration 1912, the Code of Civil Procedure 1939, etc. With these new enactments coming into force, many portions of the Civil Code of 1867 have been repealed either expressly or impliedly. Further, the Civil Code of 1867 has itself been amended a few times. When Goa was liberated, Parliament thought it fit that the laws enacted during the Portuguese rule governing the people of Goa with respect to their marriage, divorce, succession, etc. should continue to remain in force, and accordingly the various personal laws in force in the rest of India were not extended to Goa. But to whom does the civil code and the other laws such as the law of marriage, law of divorce, etc. apply to? Does it apply to all persons who reside in Goa, whether they were of Goan origin or not? Does it apply to persons of Goan origin who are no longer resident in Goa? These are legitimate questions which would require an entire session to be dedicated to it. However, for the purpose of the present discourse about anti-nuptial deeds under the Goan law, we can broadly define a person of Goan origin as someone who, or either of whose parents, or any of whose grandparents were born before the 20th day of December, 1961 in the territory of Goa. Therefore, when two persons of Goan origin get married, the civil code and other laws in force in Goa govern their marriage. But what happens if A. a Goan male marries a non-Goan female, or B. a Goan female marries a non-Goan male? The civil code states that the marriage is governed by the law of the male spouse. So therefore, when a Goan male marries a non-Goan female, their marriage is governed by the civil code and other laws in force in Goa. However, when a Goan female marries a non-Goan male, their marriage is governed by the law of the non-Goan male spouse. Consequently, it is understood that when two non-Goans get married in Goa, their own personal law will govern them, and the Civil Code of 1867 and the other laws in force in Goa will not apply or govern to such marriage. Now, having broadly understood as to who is a Goan and to whom the Goan laws of marriage will apply to, let us now consider the kinds of matrimonial regimes found in Goa. The four matrimonial regimes found in Goa are as follows. 1. General communion of assets. 2. Absolute separation of assets. 3. Communion of acquired assets. And 4. Dotal regime. Now, the regime of general communion of assets is the default regime of marriage in Goa. Therefore, all marriages of persons of Goan origin or where the male spouse is of Goan origin are of general communion of assets, unless the contracting spouses specifically choose to be governed by any of the other three matrimonial regimes. Broadly speaking, the matrimonial regime of general communion of assets would imply that all assets, present or future, which belong to one spouse, belong to the other spouse too, unless law excludes the same. An example of general communion of assets is where one of the parties owns a house and the other party has no assets at all, and where the parties choose not to execute any antinuptial deed, their marriage is deemed to be governed by that of general communion of assets. This would mean that the house which originally belonged to one party now belongs equally to both the parties, with both the spouses now having 50% share in the same. However, when the intending spouses choose not to be governed by the regime of general communion of assets, they need to compulsorily enter into an antinuptial deed. When the parties get married under the regime of absolute separation of assets, it is necessary that the parties expressly declare in the antinuptial deed that they wish that their assets, present and future, belong to each of them separately. When the parties get married under the regime of simple communion of acquired properties, the properties which one of the spouses holds at the time of marriage or gets thereafter by succession or gift shall be deemed exclusive properties of that spouse, while all other properties which are acquired post-marriage are deemed to be that of the communion. Here, it is necessary that the parties shall before their marriage make an inventory of all the properties which belong to them, failing which the said properties shall be deemed to be acquired ones. The inventory of assets can be in the antinuptial deed itself or any other public deed. Lastly, when the parties get married under the dotal regime, the wife may endow herself with her properties or be gifted by her parents or others with certain properties. If the endowment or gift consists of a certain properties, they shall be specified in the antinuptial deed. If the properties are not ascertained or predetermined, the source of such a right shall be mentioned in the antinuptial deed, failing which they shall be deemed to be common properties. The next question which arises is when must an antinuptial deed be entered into? The law requires that the parties, before the solemnization of their marriage, should stipulate as to whatever they think fit in respect of their properties. Since this deed is executed prior to the solemnization of the marriage, it is known as antinuptial deed. Once the parties choose a particular matrimonial regime which will govern their marriage and solemnize their marriage, it is not possible to change this regime or amend it in any manner by executing any other deed post-marriage. However, prior to the solemnization of their marriage, the parties are free to modify the clauses of an already executed antinuptial deed. The antinuptial deed has to be executed before the special notary ex officio, who is also known as the civil registrar. This deed is handwritten in the book of deeds. At the time of the registration of the deed, apart from the contracting parties, two other persons need to sign the said deed as witnesses. Lastly, the said deed is signed by the special notary ex officio. Since the law mandates that this antinuptial deed has to be executed prior to the solemnization of marriage, the next question that arises is, when are the parties said to be married? The reason why I emphasize on this fact is because many people are not really aware as to when their marriage gets solemnized. To put it in simple language, the Code of Civil Registration 1912, which is still in force in Goa, requires that the parties wishing to enter into marriage have to sign twice before the civil registrar. This is commonly known as the first and second signature. The first signature is the declaration signed by both the contracting parties that they wish to get married. Thereafter, the parties have to wait for a period of 10 days, including 2 Sundays, before they can sign for the second time. If the parties need to urgently get married without waiting for the 10-day period, they can request the Assistant Public Prosecutor to waive this waiting period. Only when the parties have signed for the second time can it be said that their marriage has been solemnized. In case of Roman Catholics, this second signature can be recorded in the church, and the officiating priest is like the representative of the civil registrar. In the case of Hindus, Muslims, and people of other faiths, this second signature has to be recorded in the office of the civil registrar. The reason I am mentioning this is because many times people are under the impression that they are married the moment they have signed for the first time, without realizing that their marriage gets solemnized only upon recording the second signature. Therefore, an antinuptial deed can be executed either before the first signature or between the first and the second signature. This is because when the parties sign for the second time, the parties have to state whether they wish to get married under the regime of general communion of assets, and if they state that it is under any other regime, they need to produce the certified copy of the antinuptial deed entered into by them. The next question which arises is whether there are any restrictions when entering into an antinuptial deed. Now, primarily, antinuptial deeds are nothing but contracts. Therefore, any clause in an antinuptial deed which is contrary to the law or public policy is void and cannot be effected. Now, lastly, are there any advantages in executing an antinuptial deed? The answer is yes. Now, marriage ends when a court decree granting a divorce or annulment dissolves the marriage, or when one of the spouses dies. If the couple had executed an antinuptial deed, then the parties are certain as to which assets belong to whom exclusively, and which cannot be claimed by the other spouse. So this is the first advantage. The second advantage of entering into an antinuptial deed is that it can prevent the fragmentation of ancestral properties. For example, A gets married to B without any antinuptial deed. A owned a house and B did not have any such assets. Therefore, by virtue of marriage, B becomes a 50% co-owner of the house. Subsequently, B meets with an accident and dies. Now, upon the death of B, her 50% share in the said house is inherited by her children and their descendants. However, if she had no children or descendants, then the 50% share that B owned stands inherited by her ascendants, that is, her parents and grandparents if they are alive. If they also are dead, then the 50% share that B owned stands inherited by her brothers and sisters, Only if B did not have any brothers and sisters would her 50% share in the house devolve upon A. Therefore, if B had no living descendants, but instead had only living ascendants or collaterals, then her 50% share in the house devolves upon them. So in such a situation, a house which originally belonged to A now belongs equally to A and to the heirs of B. Now, A and the heirs of B are considered as joint owners of the house. After some time, the family of B as heirs of B decide to file an inventory proceedings upon the death of B. In these proceedings, the said house is enlisted as an asset. The heirs of B then asked that an auction be held, and in the auction managed to successfully bid for the house. A is then entitled to receive only overty monies, and the house now belongs to the heirs of B. Therefore, from the above, it is clear that in case there is no antinuptial deed, then there is every chance that a property which originally belonged to one family may end up belonging to another. In conclusion, it would be advisable if the intended spouses sit together before their marriage and decide as to which matrimonial regime should govern their marriage, and if necessary, should enter into an antinuptial deed. Thank you.
We have just heard Advocate Gustavo Monterio, who has given us a very good insight on the topic of antinuptial deeds in the state of Goa. The Goa family laws are a unique and superior system of law, gender just and equitable, that applied uniformly to all, and came closest to fulfilling the objectives of Article 44 of the Constitution of India for a uniform civil code. I thank you all for tuning into this session of Virtual Juridicare series, and once again wish you all a very happy Liberation Day. And a kind reminder, do like, share and subscribe to our channel.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायद्या खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चड काळच्या केसीक बेगीन सोपयता.
आणि तेवूय सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करा.
वा टोल फ्री नंबर 151000 चेर फोन करा.